Hi, I'm Manny Fitzsimmons. I'm your Washington Realtors Legal Hotline lawyer, and I want to talk today about record retention. What an interesting topic, huh? Bear with me because this is important. Every firm is required by Washington law to keep a copy of every transaction file for a minimum of 3 years. Let me say that again. Every real estate firm is required to keep a copy of every transaction file for a minimum of 3 years. And a transaction file is required on every closed transaction. There are lots of moving parts in what I just said, and we're going to try and pick up all of those pieces before this video is over. One question I get from brokers is, how long do I as a broker have to keep my transaction files? And the answer is, brokers, you don't have a Washington law obligation to keep a copy of a transaction file. To the contrary, your obligation under Washington law is to tender or deliver copies, or the originals, to deliver documents in the transaction to your managing broker within 2 business days of when the document becomes a binding document. So 2 days of mutual acceptance of the purchase and sale agreement, or of that individual a document, if it's, for example, an addendum partway through a transaction that might modify the terms of the agreement. You have 2 days to get your documents delivered to your managing broker. Then it's up to your firm to comply with Washington law and store that transaction file for a minimum of 3 years. Brokers, if you would like to keep a copy of your transaction file, there's no reason you shouldn't. And in fact, many brokers keep a copy of their transaction files as well as tendering the documents to their managing brokers in compliance with the law. Why? Because you just might want your own access to those records. So if you want to keep a copy of the file, there's nothing in Washington law that says that you can't. You must, however, make sure you're properly tendering documents to your managing broker. Okay, I said for closed transaction files only. Is that really a good idea that you retain transaction files only on closed transactions? No, that's not a good idea. That's the bare requirement of Washington law. It's not a good idea, and here's why. If you become the subject of a lawsuit, or if a transaction that fails to close becomes the subject of a lawsuit, I'm assuming your file is going to do more to protect you than to hurt you. And so even if a transaction doesn't close, we have a sale fail, and maybe the sale fail is the reason that a lawsuit gets filed, don't you want your transaction file available to you to defend yourself using that transaction file? And you may not know at the time of sale fail that a lawsuit's going to develop. It might be a year, 2, 3, even more than that, years later, that a lawsuit develops. And so if your pattern is to just retain all transaction files, whether the transaction closes or not, even go so far as to say whether an offer is accepted or not, then you are protecting yourself with documentation that should help you defend a claim if such a claim arises in the future. What goes in a transaction file? Much of what goes in a transaction file is obvious. It would be your transaction documents, your listing agreement, your purchase and sale agreement, all addenda to the purchase and sale agreement. In addition, you want copies of all the other documents that go back and forth between the parties. Think about your inspection report if you're the buyer's broker. If you have a copy of that inspection report, it should go in your file. When you get the HUD statement, it goes in your file. All of your advertising goes in your file. Here's the one, though, that most brokers forget, or maybe you just didn't know about in the first place. All of your material correspondence has to be in your transaction file. Think about all of the emails that you send to your client. Think about the text messages that you send to your client. Think about the phone calls that you have with your client. When you have conversations with your client regarding the terms of agreement, the status of progress, whether or not they want to waive their inspection contingency, whether or not they got underwriting approval from their lender, whether or not the seller wants to send the notice of right to terminate to the buyer. All of those are critical documentary items that may protect you in the future against a lawsuit. Let's say, for example, we have a sale fail at closing, and the buyer gets their earnest money back based on their financing contingency. And the seller says later, I had no idea I could have delivered a notice of right to terminate to that buyer 30 days before we got to the closing table based on the language of Form 22A. My broker never told me that. Had my broker told me that, I would have saved 30 days of marketing time. I would have been able to sell my property. I wouldn't have, think worst case scenario, lost it to foreclosure. And broker says, but I did tell him about the ability to serve a notice of right to terminate. He didn't want to rock the boat with the buyer, so that's why we didn't send it. Well, if you're in a courtroom 2, 3, 4 years later, then it's your word against the buyer's. Your word against the seller's word. Good luck. I'm not saying you won't prevail, but I'm definitely not saying you will. It's a he said, she said, and there's no way of anticipating how that's going to come out. Imagine, however, that you have a copy of the email that you sent to the seller talking about this issue. Or even if it's a text message, you're able to use an app to load the text message in such a way that you can then print it and put it in your transaction file. Or maybe this happened on a phone call because you prefer to communicate by phone, but then you also regularly journal or make notes in your file of the phone conversations you've had with your buyer or your seller or the lender or the inspector regarding important issues, and you keep a notation of all of these discussions. Well, if 7 notations up from the bottom in some kind of a chronological order, you have discussed with seller the ability of seller to deliver the notice of right to terminate, seller declined. That is going to prove to be a very useful tool in your defense against the seller's lawsuit. But you only have that defense if you retain your material correspondence in your transaction file. So finally, let's talk about how long you should really retain your transaction files. Washington law says a minimum of 3 years. The statute of limitations on a written contract is 6 years. But the statute of limitations doesn't start to run until the party who claims injury has a reasonable basis for discovering the injury. It's called the discovery rule. And the discovery rule means that a broker and a firm can be sued for something that happened 5, 6, 10, 12 years before. And if you don't have your transaction file to protect you, then you have potentially no way of defending the allegation. Now, I am not here to tell every designated broker out there that you should keep all of your transaction files for decades, but I am going to tell you that this is something you need to discuss with your own legal counsel. Every firm should have their own office policy crafted in part by their own legal counsel that directs what needs to be retained in a transaction file that is stored for more than 3 years. We all know that that Washington law dictates what has to be in your transaction file for a minimum of 3 years. What does your firm's legal counsel want you to keep for longer than 3 years, and how long must it be retained? Final parting thought. I just told you that I'm not going to stand in front of you and tell you that you need to keep your transaction files for decades. I am going to tell you that there is one type of file, though, that you need to never, ever lose. And that is a file that creates a record of who your E&O carrier is annually and your policy number. Because if it turns out that you are sued 5, 10, 15 years from now, maybe even at a time after you've closed your office doors, you could still be sued for something, and if you don't have your records as to who your E&O carrier was at the time that the events occurred that lead to the lawsuit, then even though you have E&O insurance To cover that allegation, you're not going to be able to make a claim against the E&O carrier if you don't know who the E&O carrier is and what your policy number was. If you have questions on this topic or any other, please send an email to me. Office policies are critical for the management of the firm. I look forward to hearing from you. Thank you for being a Washington REALTORS member.